All stand. The Federal Court of Australia is now in session. Please be seated.
QUD277 of 2019. Florence and others on behalf of the Wakka people, number 4 in state of Queensland and others.
Yes.
Your Honor, may it please the court, I appear for the applicant. My name is Riak, initial C.
Yes.
Good morning, Your Honour. May it please the court, I appear for the state of Queensland. My name is Woolley, initial R.
Yes. Mr. Riak.
At Cherbourg, on the 12th of April 2022, Your Honor made a consent determination in Part A of this proceeding. Today, the Wakka Wakka people seek recognition of their native title rights and interests over Part B of this proceeding, which takes in part of their traditional country located within the North Burnett region of Queensland, roughly 400 kilometers northwest of where this court sits today. The proposed determination area includes the land and waters in and around the towns of Gayndah, Binjor, Mundubra, and Eidsvold. On the 8th of August 2022, the state of Queensland filed an agreement under Section 87A of the Native Title Act, signed on behalf of the applicant, the state of Queensland, and all of the required respondent parties. I read that Section 87A agreement. The evidence upon which the applicant relies in support of the proposed consent determination is substantially the same as the material filed and read in support of the Wakka Wakka People number 4 Part A determination. The applicant's materials are annexed within the 1st to 8th affidavits of Phoebe Claire Frederick, filed on the 22nd of March 2022, and the 1st and 2nd affidavits of Lillian May Ewells, filed on the 10th of August 2023. I read each of those materials. The applicant's written submissions were also filed on the 10th of August 2023, and I read that document as well. The applicant submits that all of the procedural requirements of Section 87A of the Native Title Act have been met with respect to the Part B proceeding. In addition, the applicant submits that the court should be satisfied that it is both within its power to make the order sought by the parties and appropriate to do so. The required parties have freely entered into the Section 87A agreement, informed by their involvement in the claim process, and critically, the state of Queensland has undertaken a review of the applicant's connection material. Based on that review, and after a process of federal court-assisted mediation, it has agreed to the proposed consent determination. Summary, the applicant's evidence is annexed in Annexure B to the applicant's written submissions. The applicant submits that collectively the connection material filed in this matter supports a determination of native title being made. The current proceeding has been on foot now for over 10 years, but the history of the Wakka Wakka people's pursuit of recognition of their native title rights and interests goes back more than 25 years. On the 12th of April 2022, Your Honor made two determinations of native title in favor of the Wakka Wakka people, with respect to areas stretching from the Bunya Mountains in the south up to around Biggenden in the north, and including Cherbourg. As noted, one of those determinations related to Part A of this proceeding. To describe that day as a significant milestone for the Wakka Wakka people would be a vast understatement. On that day, my clients achieved formal recognition under Australian law of the continuing observance by them of their traditional laws and customs, their continuing connection to their land and waters, and the survival of their identity and culture despite 180 years of colonization. That is, despite 180 years of the combined impact of dispossession of their lands, frontier violence, protectionism, segregation, and attempts at assimilation, including the forced removal of their people and internment at missions such as Cherbourg. My clients, the Wakka Wakka people, are here today, including in this courtroom as recognized native title holders. But a determination in the Wakka Wakka 4 Part B proceeding would be every bit as significant to my clients as the determinations made last year. And this is especially so for those Wakka Wakka families whose apical ancestors are particularly connected to the Part B area. Over thousands of years, successive generations of Wakka Wakka people have lived on, accessed, hunted, and fished, collected bush tucker and medicines and other natural resources, and conducted ceremonies, and taught the Wakka Wakka language, and practiced their law and custom, and maintained and protected their cultural sites within their traditional country, including the land and waters of the proposed determination area. They've done so in the face of countless obstacles that threaten their continued existence as a people. Dispossession by European invaders of the Wakka Wakka people's traditional lands within what is now the proposed determination area took place from about the late 1840s. Frontier violence against the Aboriginal population of the region is recorded from 1848 onwards. The Wakka Wakka people's determined resistance to dispossession of their traditional lands and dispersal of the Aboriginal population led to bloody frontier conflict characterized by violent and deadly reprisals. The pace of the unwelcome incursions by non-Aboriginal settlers into Wakka Wakka land picked up through the 1880s, particularly with a gold rush in the Eidsvold region, and in the early 1890s with intensive agriculture within the Burnett River region. By this time, many Wakka Wakka people had moved to permanent camps on the fringes of properties within their ancestral home areas of the Burnett catchment, including places such as Eidsvold. These fringe camps provided relative safety from the violence and killings perpetrated by the European invaders, but also allowed Wakka Wakka people to maintain their traditional laws and customs, cultural practices, and kinship networks within their ancestral home areas or estates. While dispossession and frontier violence undermined and threatened the survival of the traditional and cultural practices of the Wakka Wakka people, the policies of segregation, protection, and assimilation adopted by the colonial government of Queensland and passed into law in the 1897 Aboriginals Protection and Restriction of the Sale of Opium Act severely tested the strength and resolve of the Wakka Wakka people to maintain their traditional and cultural practices, their language, and their identity within their traditional lands and waters. And against the tide of this institutional cruelty fostered by the state policies of segregation and protection and assimilation, the Wakka Wakka people continue to live on and access and hunt and fish and collect bush tucker and their medicines and other natural resources on their land. This, in my submission, is testament to the strength of the Wakka Wakka people's culture, their laws and customs, and their deeply rooted connection to their traditional land and waters. Countless Wakka Wakka people, including many elders who have sadly passed on, have actively participated in the native title process over the past quarter century. Some of my clients are here today, and some of them were applicants on the Wakka Wakka native title claims that were lodged back in the late 1990s, and we would not be here today without their determined efforts over so many years. In my submission, it's also appropriate to acknowledge the assistance of the federal court registrars in helping to mediate the resolution of multiple matters in dispute between the parties. And it is appropriate to extend that acknowledgement to the Honourable Justice Mansfield, AM Casey, and Mr. Kim McCall, who formed an alternative dispute resolution panel and provided a joint report that ultimately led to the resolution of significant and complex Indigenous respondent issues in the Wakka Wakka People No. 4 Part B proceeding through an innovative ADR process. In my further submission, the degree and complexity of the issues that required resolution in this Part B proceeding are a direct product of the violent colonization of Wakka Wakka country from the 1840s onward, the cruel and unjust government policies that followed, and the intergenerational trauma that these things inflicted upon members of the Wakka Wakka and their neighbors within the broader region. A further determination of native title in this proceeding will not fix this, but it will be a step forward for the Wakka Wakka people in their journey towards healing and self-determination. Your Honor, on behalf of the applicant and on behalf of the Wakka Wakka people, I ask that you make the proposed determination. Those are my submissions, Your Honor. May it please the court.
Yes. Ms. Williams?
As a result of a successful negotiation and case management process, the parties have reached agreement on the terms outlined in the Section 87A agreement filed in the court, providing for the recognition of the native title rights and interests held by Wakka Wakka people in relation to the land and waters covered by Part B of the Wakka Wakka No. 4 Native Title Determination application made pursuant to Section 61 of the Native Title Act. I confirm that the state was provided with substantial material in support of the proposed determination as outlined in the applicant's submissions, and upon review of this material is satisfied that a credible basis exists to support a determination of native title in the terms now proposed to the court. Following agreement on the state's tenure analysis, the parties have provided their consent to the making of an order in terms of the draft submitted to this court. The state submits that the requirements of the Native Title Act have been met. The state acknowledges the efforts of the Wakka Wakka applicant and other parties and those who assisted and represented them in reaching agreement. The state provides its congratulations to the Wakka Wakka people in anticipation of achieving recognition by a native title determination. May it please the court.
The Wakka Wakka people have applied for a determination of native title. That application has been divided into three parts called Part A, Part B, and Part C. On the 12th of April 2022, I made orders by consent at Cherbourg, making a determination of native title in respect of Part A. I think that many of you were probably there on that day. The parties have now agreed that there should be a determination of native title in respect of Part B. Part B encompasses approximately 9,000 hectares of land and waters and encompasses the towns of Eidsvold, Londubra, Idaway, and Gayndah. On the last occasion in Cherbourg, I commented that by a determination of native title, the court is recognising what the Wakka Wakka people have always known, that the land, the subject of the determination, has always been and will always be your land. It is, once again, an occasion of great joy for the Wakka Wakka people. It is a day to celebrate. It represents a new beginning. It represents a recognition by all of the Australian people of your history, your traditions, your culture, and your rightful place in this country. It is not quite an ending, since Part C remains. However, today represents a great achievement by the Wakka people, those who represented them as applicants, and all those who have assisted them in achieving this determination. Those people who have assisted include the anthropologists Dr. Kingsley Palmer and Anthony Eales, and their lawyers, Queensland South Native Title Services. The cooperation and hard work of the respondents and their lawyers should also be acknowledged. So too should the efforts of the Federal Court's registrars and staff who have made this determination possible today. I am satisfied that orders should be made for a determination of native title in respect of Part B of the claim area. I congratulate once again the Wakka people on achieving this determination of native title. I publish my reasons and I make the orders set out in those reasons. The court will adjourn.
All stand. The Federal Court of Australia now stands adjourned.